Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It's Pam Esquire, also known as your law intellect. And welcome all of the new subscribers. I think in the last 2 or 3 days, we've gotten almost 200 new subs. It's going to say $200, but you guys are like worth and valuable. But we got 200 new subscribers. So welcome to all the new subscribers. If you have been rocking with me from day one, welcome back. I see you all piling into the chat. We have a good show set up today. I just so happened to run across this case, and it's actually filed in the state of Michigan, where I am. So it was filed in this local court. I was shocked. I knew the controversy that surrounded Darius Cooks Williams. However, I didn't understand how this internet situation just blew up where a lawsuit has been filed, and we're going to get into that. One of the people that was on the lawsuit, I think you guys saw, is Natalie, the lawyer chick. Love her. She has actually since been dismissed out of the case, but I thought that it would behoove all of us to go over her response or her motion that she filed and their response to it and how she ended up getting out of this case, because I think it's a lesson learned for all of us. It can also be a lesson learned for any YouTuber. So anytime that I can give you any information, I'm going to give it to you. Also, I believe that Natalie talked about it on her own channel. I have not been able to watch it yet, but I'm definitely going to watch it probably this weekend, and it'll be interesting to see how she broke it down and analyzed it as compared to how, we do it today. Let me speak to you guys as you come in. We want to let a few more people come in because I don't want to have to talk all over again, So once we hit a certain number, we'll get started. Cupcakes, thank you so much. Yes, please please subscribe if you haven't done so already. Last time I looked, we were about 7 away from 7,000. You guys have been so kind. You guys have been so amazing and so supportive, and I just thank you for that. Who would have known? I started my channel, I think the first time I went live was maybe last August. My first uploads were last June. I have built this channel from the dirt, and it was at the suggestion of some of you guys when you saw me on other platforms. So I am so glad that I listened to you guys. It has been such a great ride. Alice, hey. Southern Girl, hey. Sin, hey. Little Baby, hey. I know this is going to be a great show. It's going to be very informative. So make sure that you share it out. Love Jones, Paradox, Jeff, hey, Miss V, Andree. Andree said, Andree be in these YouTube streets, so she probably know, this is a good one. Yeah, make sure you guys see, because this is her, this is her thing. She lived it. And I didn't get a chance to read her entire motion we call them summary dispositions here, and I will try to break that down on that meeting as well. But again, I feel more confident because this is something that was filed here in my playground. So I'm very familiar. And it was actually a colleague of mine that pointed out to me that it was even filed and was like, hey, don't you have a YouTube channel? It's a case up the street. So yeah. Oh, thank you. I appreciate it. Thank y'all. Y'all make a girl feel good. I appreciate it. You guys are so kind, so kind, so kind. Who else we got up in here? Jessica, hey. You said she did a great, yeah, I'm sure she did. They have a hearing tomorrow. I don't know if it's on Zoom, and we'll talk about that too as we get into it, or if it's in person. But if it's in person, I might have to jump in the ride and go 10 minutes up the street and go see what's going on so we can follow to see what is going on. It was good and very interesting. Okay, so some of you guys, y'all watch Natalie. All right, cool. That's cool. Hey, Kathy, Keisha, hey. I see you guys coming in here. You said Natalie did an excellent job explaining her response. I've learned so much from you, Pam, Natalie, lawyer, chicken girl. Is that? Thank you. Y'all got me feeling all mushy on the inside. Man, you've been here from the beginning. Thank you so much for sticking by me because, child, it was definitely trial and error. Definitely trial and error. So anyway, let's just start from the beginning. So I've done one video for those of you that don't know, and it was a while ago. I did one video on Darius Cooks, and the reason why I did that video was because the hearing was actually on the internet. So there was a lady, I believe her name was Melanie Ford. Darius filed a TRO or restraining order against her. So we watched that on the channel. For those of you that don't know, Darius Cooks is like this. I'm gonna read some of the articles on him so you can see. He has been in the news with a lot of controversy going back the last 2-3 years. And there's been a lot of online beefs and dramas, apparently. I didn't even realize how deep it was. But then when I seen my girl Natalie was drawn into it, I was like, wait a minute. I don't know her for real, but she's still my girl. That's my sister counsel. But I said, well, how did it get to this? I was like, what? How did it come to this? It's very, very interesting. Just we're kind of in a litigious nature out here where people are just filing lawsuits. And you guys need to be aware of that, especially if you're on here doing YouTube, right? Because you wanna be able to watch yourself and cover yourself and know that there's some people out here that even no matter what the beef is, what they seem like they participating, they may try to sue you. So I'm just gonna pull up a few articles on Darius so we can just like we did before, just give a little bit of background so we all know because I don't really follow a lot of these people. I don't follow. So I don't have probably the information that many of you guys have. So if feel free to tell me when I'm wrong, feel free when it comes to the facts. Tell me if I'm wrong about what's going on or if there's anything that I missed or whatever. We're not here to bash anybody. We are here to go over the complaint. We're going to go over Natalie's motion for summary disposition, the response, the judge's order, and why I kind of agree with the order, but I kind of don't agree with the order. And we're just going to see, we're going to go from there. So the Darius Cooks William Skillet controversy explained. Let's start with that. And let me make sure we put myself down here at the bottom. Hey, everybody, as you come in, make sure you hit that like for me and subscribe if you hadn't done so already. If you haven't heard, we are like seven away from getting to 7,000. It's going to be a lot of commercials. Y'all know how this stuff works. So Darius Williams skyrocketed to fame after TV chef Sunny Anderson invited him on her Food Network show, The Kitchen, in 2011. But if you bought a skillet or another product from Darius Cooks, the company set up around the influencer chef, and it has not yet arrived, don't hold your breath. The Better Business Bureau lists 13 complaints against the company's Jersey City center and 19 against the Atlanta-based one in the last year alone. Complaint upon complaint describes situation in which products were never shipped or sent to the wrong address without a refund and events canceled due to COVID-19. The Darius Williams also refused to reimburse customers for Darius Cooks in Atlanta. Oh, for a period. I'm reading like it's not a period right there. I'm sorry. Darius Cooks in Atlanta has an E rating for failing to respond to complaints, while the Jersey City business has no rating while its file information is being reviewed and or updated. These activities are just part of the reason why Williams is controversial, and the hashtag Darius Cooks has continued to be viral. The whole set, of course, however, is a laundry list of alleged scams, scandals, lawsuits, and bankruptcies. On August 21st, 2021, Angela Davis, a private chef who goes by the Kitchenista, which is who filed this lawsuit here in Michigan, posted on Twitter a then current record of allegations that plagued Darius Williams' ventures, although her Twitter account no longer exists. In September, the Kitchenista also shared public records of lawsuits against Darius Williams and Darius Cooks on Facebook. They cover multiple allegations, including the unshipped products and various unpaid bills. The controversy around Darius Williams has been hanging around for more than 2 years. For example, an early appearance of Darius Cooks on Instagram occurs on a post from February 2020. In it, Williams is accused of not giving his coworkers time to recover after a robbery, framing them for overcharging the credit cards of his followers, and having manager pay for food supplies themselves with recompense. Then in June 2021, the controversy reached a new level when one Instagram user brought up the records of the Better Business Bureau and alleged that William plagiarized the Kitchenista. This brought the two into contact, prompting her to post on Instagram accusations that Williams assaulted a female server in 2019 after she says he refused to pay her. Quote, "I will not let this go. The allegations are piling up of scams, outstanding refunds, and now physical assaults against Black women," end quote, the Kitchenista wrote. All these incidents were picked up by the Southern Grit magazine in late 2021. Williams did not respond to their request for comment. However, judging by both the continued existence of hashtag Darius Cooks and the steady stream of new content and engagement on his Facebook page and Instagram account, he still has a fan base, despite the series of scandals and Skillet controversies that are now tied to his name. So this gives us a little bit of a background on Darius. Let me do another. We'll do one more on him. And let's see. So it's just been a lot. So him and the Kitchenista sound like they've been going at it for a little while now. And apparently this has come to a head and it's ended up in court. So let me see. And I was gonna reach out and see if anybody wanted to come on, but then when I seen how messy this stuff was getting, I said, y'all not about to be putting me in this. I'm just gonna go over these documents, and I'm gonna mind my business. You guys will not. This is getting ugly out here. AC said it all started in Chicago. He still owed a company in Chicago. Oh my goodness. Little baby said Darius is a whole mess. Yeah, it's not they clearly have a rival going on, but apparently it must have went to a point where she decided to file a lawsuit against him. It's very messy, hard to follow if you didn't witness it go down. Yeah. So all I can do is I can go by again the articles that have been out. Of course, this is their opinion. This is my opinion. This is their opinion. And so I'm just trying to give you guys a brief background before we get into the lawsuit that was filed. Let me see. And then he had Dining with Darius. Now, I do remember this. So Dining with Darius accused of giving homeowners heaping helping of heartburn. And this was published April 19th of 2022. So it was last year around this time. Online food personality Darius Cooks Williams may have violated multiple short-term rental rules plus the city ordinance when he hosted a paid event last month in Atlanta. This comes 1 month after a verbal homeowner in Texas called police to have Williams removed when she realized what he was really doing in her home. Williams 40 charges $215 each for a 7-course meal he prepares and serves to customers in various cities around the country. The price is due to rise to $289 next year. He pushes the events through his social media pages, some of which claim more than 1 million followers. But his Atlanta-based company, Darius Cooks, has been the subject of numerous complaints from customers who say they did not get what they paid for. When Williams ignored their complaints, some unhappy customers posted their concerns on his social media site. Williams responded by blocking critics or posting their private information online to alert his followers. Some would have them bombarded. The original posted with offensive remarks. Williams' company has an F rating with the Better Business Bureau. So now you see right here. So he made the news. The news was following him apparently. See, the picture says we tried to ask Darius Williams questions at the Verbo House a few hours before one of his dining with Darius events. He had no comment and shut the door. So they was following him, the news, because of these alleged complaints. Again, these are all allegations. From March 17th to the 22nd, Williams held one of his dining with Darius events in a house on Northside Drive in Collier Hills. The house was booked through the short-term rental site. House rules for that address forbid any, quote, events and limits the number of guests to 8. Videos posted by participants show far more than that. Williams often sells 30 tickets per event. Oh, wow, said the home's property manager, Toby Jackson, when shown a picture of the event. I come before the guests and after the guests. Did he expect 30 guests in this house? No, sir, Jackson answered. So sounds like people were tipping off the homeowners, like, your listing says you can only have so many, but look how many people he got up in here. Let's continue. The homeowner works out of state and could not be reached for comment. Williams told the Fox 5 I team he broke no rules but would not provide any proof. The homeowner knew that he planned to do what he planned to do with this property. The house is now for sale. Williams also regularly serves sangria to his paying guests. At one location, home video shows guests dipping their cups in a communal plastic bucket. He's also posted videos explaining he makes his sangria with rosé wine and cognac. In Atlanta, one customer posted a video on the way home from the event showing her slurring her words with the graphic saying that the red drink sangria is kicking in now. Atlanta police say a paid event with alcohol should have a special use permit. None was obtained for the Collier Hills house. Williams declined to answer the Fox Eye team's questions about whether alcohol was served and why he didn't get the proper permit. Another short-term rental company, Airbnb, confirmed Williams is prohibited from using their site. This is a picture of a former Darius Cooks worker. Says he asked to use her Airbnb account to book his next event. The homeowner later sent her a $10,000 bill for damages. Ooh, my heart would have hit the floor. The ban appears to go back to at least 2016. That's when a former worker named Nadia, she asked us not to use her last name, said Williams approached her about using her Airbnb account to book one of his events. Quote, my first week working for him, he was like, wow, I'm having trouble getting into my Airbnb. I don't know what's going on. She remembered. She would come to regret her decision to book the location with her own Airbnb account. Imagine my surprise when a week later I get an email saying, hey, you owe Airbnb $10,000 because you trashed this person's house. She told the homeowner Williams was responsible and wound up not having to pay the damages. If you're a business owner who messes up your reputation on Airbnb, you don't have another driver's license, you got to find another sucker to use their accounts. That's in good standing to continue your business, she said, pointing to herself. So then you got in February, a Dallas, Texas owner called to remove Williams when she said she realized what he was doing with her home. She said Williams had blown the electrical system by hosting a commercial kitchen dinner without her permission. Instead, Williams made sure to go live on Instagram to accuse the homeowner of being the real bad guy. He canceled the rest of the Dallas events, but some of the customers reached out online when they didn't get a promised refund. No response from you at all and no refund for the 2 tickets I purchased. I'm out $430 and a plane ticket. How long will it take to get my refund from the Dallas event? He blocked me immediately without responding. So then Darius said, they posted this from Darius. It looks like, hey, can you do me a favor? I'll explain later in full detail. Can you text and call Jason and Kelsey and tell them to call Darius? They have my number. FYI, Dallas, I have to cancel the remaining dinner parties. I'll email you shortly and I'll go live later to explain. Most legitimate companies will respond quickly to customers who complain they didn't get the product or service they paid, but Darius uses tactics no legitimate company would even dare consider. So I think you guys get the gist here if you didn't know already. Been a lot of complaints, been a lot of things going on, but now this has led to the Macomb County Courts under the Judge Servito, and this is the lawsuit that was filed. So a complaint was filed, and I have blocked off addresses. Very interesting. This is a verified complaint, which essentially means that the plaintiff, which is Angela Davis, or the Kitchenista as she goes by, signed this complaint. And she brought this lawsuit originally against Donovan Holland. I don't know who that is. Maybe somebody else can tell me. We get a little bit more information when we get into this complaint. Danielle Holland, Darius Williams, and as you see, Natalie, who has since been dismissed out of this case. Okay, y'all make sure you hit that like button now. We about to get into it. So when you start out, of course, you do jurisdiction and venue on why this court should be allowed to hear this case. Angela essentially says she lives in Oakland County. I thought it was interesting because everybody else's address was on here, but she just put Oakland County for herself. Donovan, they're from here as well in Michigan, and then Darius is from Georgia. The only reason why I'm telling you the areas that they're from, because it will become important later on when we get into this complaint. And then we have Natalie, who is a Maryland resident. So let's go into the factual allegations. We all know it starts out when people give their facts, their rendition. Again, these are allegations, as you see right here. This is their version of the story. And then you will have the defendants, they'll give their version of the story. And you will see like what Natalie's version of the story is as well. You said Don Vaughn. Okay. Thank you, Andrew. So boom, the Hollands jumped on the bandwagon against Darius and his scams. Then he doxed them online and was posting pictures of their kid. Oh Lord. So this is what it sounds like, just generally, without me first getting into the allegations, that when a lot of this stuff with Darius started happening, there were some people that almost looked at warning people about these alleged scams became one of their missions. So with Angela Davis, or the Kitchenista, as you've seen from the article, she was posting, putting complaints, all of that stuff out there. To me, it looked like they was going back and forth on the internet. It was getting a little rough. And then the Hollands, it sounds like they may have got onto, the same situation. And then, like you said, doxing and all of that. So, y'all, I did not know that YouTube and social media gets this grimy. I was really shocked. So again, I heard about the stuff with Darius, but I really didn't know how deep this got, that it got into the courts, people spending their time and their money. It's unbelievable to me. So I felt it was worth going over. And again, it can be a lesson as well for a lot of people. So let's get into the facts. Plaintiff Angela Davis is a social media influencer who enjoys a wide range of success on various social media platforms such as Facebook, Instagram, Twitter, and TikTok under the identity of @thekitchenista, where she demonstrates how to prepare various home-cooked dishes and shares recipes with her followers and/or subscribers. Plaintiff Angela Davis's success as a social media influencer has led to a source of income for her, which also has led to a reasonable expectancy of revenue based on followers who like, view, and share Ms. Davis's content, which has continually been posted on a regular basis. In June 2021, plaintiff began receiving false and defamatory allegations against both herself and her brand identity based on misrepresentation from defendants. So she's claiming that as of June 2021, she began receiving defamatory allegations against her and her brand as the Kitchenista against all the defendants that we just named. By way of example, somebody said the social media stuff is out of hand. Angela is giving obsessed. Her recipes are bomb. Okay, so Angela, they said your recipes are bomb. By way of example, defendant Darius Williams began a smear campaign which targeted plaintiff based on what is perceived as retaliation for plaintiff's involvement in a series of interviews with reputable online media outlets such as The Shade Room, Forbes, Black Enterprise, The Griot, Southern Grit, and The Daily Beast, all of which were published in July of 2021. Defendant Williams engaged in numerous antics on social media, including going onto where live streams where he would direct his followers to direct harassing comments, messages, and posts towards plaintiff. You know, the plaintiff is the Kitchenista. That further, defendant Williams pulled a background check on plaintiff where he read her personal information, including her address and phone number, to all viewers, and further stated that he had plaintiff's social security number and would release it to anybody who wanted it. This is just crazy. When I was reading this, I'm like, what? Then further, defendant Williams created a discount code for his own website using plaintiff's identity, Kitchenista, as the code in order to solicit followers of plaintiffs to purchase products from defendant's online store through Shopify. Defendant enjoyed success in the form of sales exceeding $110,000 from this instance, which he bragged about on social media. Additionally, defendant Williams said sold a course on how to profit from a social media dispute, highlighting his dispute with plaintiff. Based on defendant Williams' conduct, plaintiff received public and private messages as well as comments calling her derogatory names, bodily threats of harm, weaponizing a diagnosis of bipolar against plaintiff, and falsely claiming that plaintiff was, quote, in a crisis and off her meds, end quote. In the same time frame, plaintiff was also being harassed by hundreds of Twitter and Instagram users demanding that plaintiff shut up and cook. In February 2022, defendant Danielle Hollands' name was also exposed to the public in the same fashion by defendant Darius Williams. Alarmingly, Mr. Williams also thought it was acceptable to post a picture of Miss Hollands with her two minor children, whose faces were not blurred, with the caption, "Everyone say hi to Danielle Hollands." That's what you were talking about in the comment. That made this lawsuit. Once again, Mr. Williams threatened to release all of Miss Holland's personal information on live stream. Having been a victim of this conduct herself, plaintiff reached out to defendant Holland in efforts to assist with placing locks on credit files. Plaintiff was placed into a group text message with defendants Girl, I know you told me how to say it, so I'm just Don Vaughn. Is that what you said? Y'all know what I mean. Holland and Danielle Holland in February 18, 2022, where defendant Holland asked for assistance in sharing the story about having their personal information be released, a practice informally known as doxing by defendant Williams. Plaintiff agreed to assist the Hollands. On February 19, 2022, plaintiff hosted the Hollands on her Instagram live stream. When the live stream started, the Hollands appeared live from their home. They were given the opportunity to speak freely, to share their encounters and dealings with defendant Williams. The Hollands expressed gratitude regarding plaintiff's assistance in the parties' group text message. Thereafter, Don Vaughn Holland reached out to plaintiff concerning the sale of merchandise for which the proceeds would be remitted to the Cyber Smile Foundation on plaintiff's website. Plaintiff respectfully declined based on a lack of evidence of a tax exemption for the charity and other gaps in their business plan, despite plaintiff requesting same in writing to verify the charitable cause behind same. Unfortunately, based on plaintiff's respectful decline of defendant Don Von Holland's offer on April 7, 2022, the Hollands began their own disparaging campaign of plaintiff, falsely claiming that plaintiff intentionally made $55 in profit from their live stream on February 19, 2022. On September 20th, 2022, defendant Danielle Holland continued these harassing and threatening remarks, making tweets that involved threats upon plaintiff, which mandated Royal Oak Police Department. Thereafter, defendant Natalie E. Whittingham Burrell also joined up with the Hollands, sharing disparaging remarks on Twitter as recently as September 2022, calling plaintiff unhinged and labeling her as upset that the attention is not on her, going so far as to call plaintiff sick, which has further led to damage to plaintiff's brand, image, and reputation. When I read that line, I said, I know this is not all that she's saying that was said about her. So all of that, you hear a whole lot about Williams, and then is one line as it pertains to Natalie, the lawyer chick. Based on the defendant's conduct, plaintiff has endured severe damages to her personal image and her brand image, loss of followers, which translate into loss of income for her social media platforms, as well as emotional distress as a result of defendant's conduct. So count one, she claims defamation. She says the accusations that were lodged against plaintiff by defendant were false. Defendant published the remarks to third parties with knowledge of the falsity of the statements or in reckless disregard of the truth or falsity. Publication was privileged. Publication of these remarks has resulted in damages. So she puts all these lists of damages, loss of career opportunities, the time value of money and revenue from the interest that would have accrued had plaintiffs been able to maintain their banking relationship with defendant, emotional distress, humiliation, mortification and embarrassment, sleeplessness and anxiety, other damage that may arise during the course of discovery as this litigation progresses. Defendant's accusations and the publication thereof were defamation per se. Okay, first of all, I'm going to stop right there. In the state of Michigan, you have to plead with particularity. Therefore, if I say, first of all, defamation per se is when you commit a crime, unchastity, something about your business, and there's a fourth one. I can't think of it right now, but you get my drift. It's pretty much the same in most states. I don't really see defamation per se as I'm looking in this. I'm going to read further, but I don't see defamation per se. Also, when it comes to defamation, you have to say the exact quote. So if I say, Andrea was caught on the corner as a prostitute, unchastity, that's it. She was on the corner and she married and she's on the corner. I seen her, on the corner with some guy trying to allude that maybe it was some hanky panky going on or something like that. I need to be able to quote specifically what was said. So it has to be with particularity. Also, the Kitchenista is a public figure. When you are a public figure, you have to prove malice. And this is something that I told you guys before in some of the other cases that we had. You do have to prove malice. Maybe we'll get to that. Intentional infliction of emotional distress. Very hard to prove in the great state of Michigan because you have to show extreme and outrageous behavior. So this is, I haven't even seen anybody that's been able to win on intentional infliction of emotional distress, but we're going to read what that is. Defendant's conduct was outlined was intentional. I was trying to see your comment. Defendant's conduct is outlined above was extreme, outrageous, and of a character not to be tolerated by civilized society. Defendant's conduct is outlined above was for an ulterior motive or purpose. Defendant's conduct resulted in severe and serious emotional distress. So then she has and all this is against all the defendants we named, torturous interference against all defendants. The statements made by defendants falsely accused plaintiff of unethical and unlawful behavior in an attempt to harass plaintiff and deter others from following plaintiff, viewing her content, or engaging with plaintiff's online store. Plaintiff had business relationships and expectancies, had a reasonable likelihood of future economic benefits for plaintiff in the form of social media revenue, sponsorship opportunities, television opportunities, and online store sales. Defendants knew of the contracts and business relationship and expectancies between plaintiff and her followers. So she's saying she has a business expectancy between the plaintiff and her followers. By their conduct described throughout this complaint, defendant intentionally and improperly interfere with the contract and business relationship and expectations of plaintiff. The conduct outlined throughout the complaint was intended to and did interfere with the contracts and business relationship and expectancies, causing their breach, disruption, or termination. Then they're saying as approximate cause she was injured. Count 4 is torturous intrusion against defendant Darius Williams. Plaintiff's personal information, such as her full name, date of birth, address, and social security number, is both personal and private to her. Plaintiff had the right to keep this information private. Defendant sought to learn information regarding plaintiff's personal information for the express purpose of disseminating its social media followers in an effort to retaliate against plaintiff for speaking factual information about defendant in several interviews to reputable media outlets. Defendant's actions and intruding on plaintiff's right to privacy were highly offensive to plaintiff and would be highly offensive to a reasonable person. Defendant's invasion of plaintiff's privacy caused plaintiff to suffer extreme emotional distress and humiliation. Okay. So that count was only against Darius. It was not against all of the other defendants. Count 5, torturous publication against defendant. This is only against Darius. After defendant learned of plaintiff's information, he posted the information on social media disclosing her information. So all of this about is him posting her personal information. So against all defendants, is count 6, and it is false light against all defendants. In making statements online via social media, defendants made false statements regarding plaintiff public. These statements were false at the time they were made. Defendant knew these statements were false at the time they were made, or made these statements with reckless disregard as to whether or not the statements were true. The statements that defendant made were extremely embarrassing to plaintiff and caused them to suffer humiliation, extreme emotional distress. The false light in which defendant allegation placed plaintiff in were highly offensive to plaintiff and would be highly offensive to a reasonable person. These actions by defendant caused plaintiff to be damaged in ways including but not limited to loss of career and economical opportunities. And then she has, I declared the statement is above our truth to the best of my information, knowledge, and belief. So they had her verify all the information that was in the complaint. You don't always have to get it verified. You can just do a regular complaint. But when you do a verification, it's almost similar to like you doing an affidavit. So, but anyways, I'm going to look in the comments real quick before we get into, we're early on in this case. So this was filed in February. All the parties answered. For the most part, it's straightforward answer. I would have to do it side by side, which would take all day. They denied, a lot of the allegations. Plus, again, they're jurisdictional issues because Natalie doesn't live here. Darius doesn't live here. So we knew there would probably be some issues related to jurisdiction. So Natalie, she went pro se, but as you guys know, she is a defense attorney in Maryland. And so she went pro se and she learned these good Michigan laws because she did from what I've been able to read, she did a written brief. And it's called a motion for summary disposition. In Michigan, it's MCR 2.116. This is how much I always file them. And there's different numbers, like different subs. So like C1 is if you have, judge, you should dismiss this based on jurisdiction. This court doesn't have jurisdiction on me. I like you guys, respect you, but you don't have jurisdiction over me. I'm not from here. Then you have like C8, which is fail to state a claim. That's the most typical. Then we have C10. But when you do a MCR 2.116 C8, it's essentially saying that based on the pleadings, like how I just read, and I was like, I ain't no particularity. I don't know what quotes. What are the defamatory statements? Unhinged can't be it. Those type of things based on the pleading alone. The court doesn't look outside the pleadings. They just look within your pleading, their complaint, your answer, and they're like, okay, yeah, this should be dismissed based on the fact that your complaint ain't saying, there's no basis for it. Or you can do what's MCR, it's called MCR 2.116 C10, which you get to add documents outside of the pleading. Now, the thing, you attach exhibits, your proof on there. Most of the time, you don't do a C10 until we go through discovery, which is depositions, subpoenas, and all of that. So that's the difference. You can do a C8 and the judge will do it directly on the pleading and say, it's nothing here. But oftentimes, if you try to do a C10, you wait till after discovery, because the argument on the other side, if you try to do a C10 this early on, they're going to try to say discovery is in its infancy, because I've done it. So I know that's what you're going to say. Discovery is in its infancy, Your Honor. You shouldn't dismiss my case because we may continuously go forward and then it's more information that we didn't know about. So Natalie filed an SD. From what I saw, it looks like she did it based on C8, saying that as we look at the pleading, it doesn't look like they have a claim just looking on the pleadings alone. But she did something, it's very thorough because I haven't went over the exhibits, but she did attach a whole lot of exhibits. But it just bolstered, I think, a lot of the information that she had in her motion, because this really wasn't a C10, because again, the other side would have said, well, we haven't got through discovery yet. So why are we doing a C10 motion? But the judge does have the right to do it on the pleading. Plus, I believe she did a C1 as well because there's a jurisdictional issue. The thing with defamation is you can use the long arm statute and get people from other states if you can show that they harmed you in the place that you're domiciled. So she will have to show that there was a tort here where she lives at. And then perhaps it may be where we can get jurisdiction. So it's a lot to that, but I want to go over her motion. Let me see. Quick question. Did Natalie reach out to you about filing this prior to filing her response when you want to say yes? No, nope. I literally just saw this. Nope. I don't even know Natalie, Mr. CKB. I just found out about it because one of my colleagues saw it and was like, did you hear about this? And I knew, I knew who the people were just from being on YouTube, but no, I can't take credit for that. This is all Natalie. She said the judge commented on how well it was written. Oh, I'm sure. Judge Servito let you know. I follow Natalie too. The whole thing is kind of bananas. I'm sure she's glad it's over because I would. He said, how you sue a defense attorney with no grounds. She went on and see, that's what I was looking at. I thought it was interesting because I'm looking at all these articles and all of these different platforms that this person went on with, the Kitchenista went on, and it just seems like it was, she said something, he said something, he said something, she said something, she said something. It just seems so mutual. And again, I'm coming behind the 8 bar because I don't really know. I haven't followed all of what has been going on because apparently if they say they were hashtagging his name back in 2020, this has been going on for quite some time. So I'm 3 years behind. So most of the stuff that I know is based on what you guys tell me or what I see, on the internet, seeing these articles. Yeah, and most of she has to prove that it's false, whatever was said, but it has to be a defamatory statement, and it can't be opinion. And to me, calling somebody, like I seen in the complaint, the word unhinged was used. That sounds more of an opinion. That doesn't sound like to me that it is defamation, because the courts are going to protect your freedom of speech. So there's always a balance between freedom of speech. They don't want to step on it, and defamation. There's a Reddit thread about dude before 2020. Oh wow. So he been out here for a minute. To be fair, he did a lot of vile things to her, but that's him, not everyone else sued. Yeah, okay. So Culture Love said that he did do a lot of vile stuff to her. So you think it went way beyond whatever their beef was back and forth. He took it to, how they say when they go low, somebody go to hell. So you saying that she went low and then he went to hell? Is that what happened? It's interesting that suing him because she started the Darius Cooks movement that summer, not trying to defend him because I believe the accusations, but she definitely started it. And that's what I'm looking at. And another thing is you have to prove damages. First of all, I didn't see nothing about malice in here. She is a public figure. So malice is something that has to be proven. So that was, to me, I just seen that deficiency almost outright. Also, how do you prove like what if Darius, and this is not to defend Darius because it sounds like it may be something, I don't know. Everybody, you know how I am. Innocent until you prove guilty or liable or whatnot. I am that, everything is allegations. But if you made money off of this beef, let's just say before you started doing the hashtag Darius Cooks and going on all these platforms, your followers increased, your revenue increased. Like a lot of your stuff just doubled because of you being in this controversy. Sorry. How do you say you were damaged when you're almost I'm not gonna say because obviously, you guys said she has good cooking and good cookbooks, and she may have been doing well before this, and I believe that. But what if your revenue actually increased because of this? How would you handle that? He was stealing her recipes and publishing them in his cookbooks. Lord, oh, now see, that's the stuff you sue for if you can prove it. If it's copywritten, you know what I'm saying? I remember reading Lipstick Alley Threads back in 2016 that talked about his scammy cupcake business and food truck. Lord, I followed her, watched it from the beginning. She was advocating for other people that he actually harmed and was pressing people to come forward to join her. So I'm gonna ask you too, Feisty. Once she decided to make this a movement, let's just call this a movement, do you think that her sales increased and her followers increased, or did it decrease? And if it did increase or decrease, was it substantial or was it? Matter of fact, she got into it with Kev on stage trying to force him to. Oh, this is deep. All right, y'all. We'll be here all day. So let me get into Natalie's response. Let me see. Well, not response. I'm sorry. She did a motion for summary disposition. Let me see. That's their response. So Natalie responded with a motion for summary disposition. I explained what the motion for summary disposition is. Essentially, she's asking for this case to be dismissed, and she'll get into the reasons why. So, Plaintiff Angela Davis is a public figure based in Michigan. Plaintiff currently has 180,000 Instagram followers. At its peak, Plaintiff's Twitter account had up to 154,000 followers. Plaintiff maintained a popular food blog website, the Kitchenista Diaries. Both the website and Twitter account became defunct sometime in 2022. While active, Plaintiff utilized her social media platform on Twitter and Instagram to raise awareness about allegations of financial malfeasance made against co-defendant Darius Williams, aka Darius Cooks, hereinafter Williams, under the hashtag Darius Crooks. So she starts out saying what you guys are saying, and she is establishing what I just said, that she is a public figure. That is why she's talking about the number of followers, the blog that she has, that essentially she was known. She is a public figure. Defendant Natalie is a public defender who resides and works in Prince George County, Maryland. Defendant also operates the YouTube channel Natalie Lawyer Chick, which currently has 120,000 subscribers, and a Twitter account which currently has 21,400 followers. Defendant uses this social media platform to provide commentary on popular topics which intersect with the law. Defendant produced a multi-part YouTube series on the allegations against Williams. So this is how she's saying she somehow got involved, because she was one of the individuals that was doing commentary as it relates to Darius Cooks Williams. On September 6, 2021, defendant sent a direct message to plaintiff to request background information from plaintiff on Williams. Plaintiff agreed to speak with defendant and requested that defendant provide plaintiff a referral for a defamation attorney in Michigan because plaintiff felt that she had been defamed by what. So she reached out to Natalie asking her for an attorney and then ended up suing her. Defendant provided a referral to plaintiff and a meeting was scheduled between plaintiff and defendants. Plaintiff and defendant met several times via Zoom over the course of the year. Defendant interviewed plaintiff about the allegations against Williams, and plaintiff provided defendant with documentary support for her claims in the way of background checks, arrest reports, and photographs. Oh my. Plaintiff also informed defendant that plaintiff used anonymous accounts. So plaintiff informed defendant that plaintiff used anonymous accounts to discover additional information about Williams. So y'all telling me people are creating accounts that don't have their name on it? I guess because they probably get blocked in their first day. So all these dummy accounts, I guess, so they can follow folks and still stay up to snuff and make sure that they can watch and get information on you. I told you guys you're going to learn how this thing works when you read this lawsuit. These conversations culminated with a recorded interview in February 2022. This interview was uploaded on YouTube on April 6, 2022. Defendant uploaded 6 videos to YouTube in what became known as the Darius Cooks series, centered around in addition to plaintiff individuals interviewed for the series included co-defendant Danielle and Don Von Holland, hereinafter the Hollands, an ex-business partner of Williams named Lavelle Baker. In total, the series garnered over 170,000 views. Plaintiff reposted some of these videos to her Instagram account. So it sounds like Natalie was doing these videos and the plaintiff was reposting some of the content on her own Instagram account that was done. Around August of 2022, defendant became aware of, quote, infighting, end quote, between these interview subjects and consequently ceased uploading content concerning this topic. So she's saying once she became aware of some fighting amongst the people, she stopped talking about the topic. It was around this time that plaintiff began posting online messages about being upset with the direction of the movement. On August 17, 2022, defendant emailed plaintiff. That same day, plaintiff responded that she was dissatisfied with Melanie Ford, another interview subject, and that she would like to speak to defendant when plaintiff is back from vacation. And she has that as Exhibit 1. And Melanie Ford, if you guys don't know, she was the one I talked about at the beginning of the show where there was a restraining order. It was allegations that I guess she was following or stalking Darius. So Darius filed a TRO against her, and we watched the hearing, and he lost that hearing or lost that request. On August 27, 2022, defendant's mother, who resides in New York, became extremely ill, and defendant needed to go to her mother in her time of need. Defendant's mother is a stroke patient who is paralyzed on one side of her body, and defendant is her medical proxy. That's Exhibit 2. This was an exceedingly traumatic experience for defendant, and as a result, defendant lost interest in communicating about Williams, Davis, and Ford. So she had life that happened, and then she didn't really want to be involved in all of this that was occurring. So I'm going to go down to, let's go down to Exhibit 2, because as you see, she had all the exhibits on here. So Exhibit 1 and 2, this is the email. You can't see it. I can't even see it very well. So it shows the communication between the two. Exhibit 2, she must be showing, looks like she may be having a conversation about, so she says, mommy is in the hospital. She's showing the court that her mom was sick. And then, oh my God, they're trying to go back to sending her to ICU. And then the response was, why? Because she's doing better. And then she said she's not, though. The doctors are fighting with the nurses. The nurses want her to go to ICU because she's unstable, and the doctors want to keep her. Why do the doctors want her to stay? You know, she's just showing the court that she can back up every line that she's saying. Even the fact that she has text messages to show that her mother was in the hospital at that time. And again, I know she did her own video, so maybe she got more into that. But those are exhibit 1 and 2. Yeah, a movement. So she don't like the way the movement is going. Okay. Oh goodness. Let me get back up here. On September 2nd, 2022, defendant returned to Prince George County, Maryland, and herself underwent a medical procedure on September 4th, 2022. So I'm assuming that's probably her medical record that she attached. On September 5th, 2022, while defendant was still recovering, plaintiff emailed defendant requesting help with de-escalating a feud with Melanice Ford. Defendant did not respond to this email because defendant did not see it as defendant was recovering. So around September 5th, 2022, she's saying that she received an email. She was recovering from surgery and she receives an email from the Kitchenista to try to de-escalate. She wanted her, I guess, to be the mediator between a feud that was between her and now Melanice. And it sounds like Melanice may have been a part of the movement before, but they must have fell out somehow. So on September 18, 2022, defendant received an Instagram DM from plaintiff. In the DM, plaintiff informed defendant that she would no longer appear on defendant's channel if defendant continued to associate with Ford. What? So the Kitchenista, according to Natalie, DMs her and said that if you still continue to associate with Natalie Ford, I'm not going to be on your channel. Plaintiff also expressed her displeasure that defendant had not responded to her. Defendant did not initially see this DM until defendant was at home recovering from a second surgical procedure on September 20th, 22. And this is how I know that Natalie is a good person, because the fact that she put in here, I just didn't answer her because I didn't see it. I probably would have been like, and I didn't answer it. You know what I'm saying? Like, she was really making sure she was being delicate. Like, I was not purposefully trying to ignore you. When the next person probably would have been like, okay, I get hundreds of emails. So I overlooked the email to kind of, and it's times, I'm not going to lie, I open up the emails and I might scroll and see which ones look important, if it's from the court or if it's from whatever. And I may not really get to your emails till later. But the fact that she was making it clear, I was not purposefully or intentionally trying to ignore you. On September 20th, defendant responded to plaintiff. Defendant expressed that she was not involved in this dispute between Ford and plaintiff and did not wish to be involved. Defendant also informed plaintiff that defendant's mother was ill and that defendant had recently undergone several surgical procedures. So she explained to her why she had not responded to her. Refusing to accept the defendant was not interested in this feud, plaintiff forced a dispute about plaintiff being unhappy with defendant for a reason which, to this day, defendant still does not understand. Plaintiff then blocked defendant. So then the Kitchenista then blocked Natalie. Then plaintiff unblocked defendant and tagged defendant in an Instagram story, a disappearing post visible to followers that lasts for a brief period of time. Plaintiff alleged that she had been abused by people in the movement against Williams and informed her followers to an anonymous Reddit account. Plaintiff alleged that she had been abused by people in the movement against Williams and informed her followers to an anonymous So apparently she has an anonymous Reddit account, allegedly. This led to the false implication that defendant had somehow been abusive to plaintiff. Wow. When plaintiff tagged defendant in an Instagram post, friends and associates of defendant who also follow plaintiff's large Instagram platform began to contact defendant and inquire as to why, quote, the Kitchenista was upset with the defendant. Having firsthand knowledge of how the plaintiff has leveraged her platform to bring about shame to other online creators and private individuals, defendant felt that it was necessary to share the totality of defendant's conversation with plaintiff via DM and email, which gave rise to plaintiff's grievance with defendant. Defendant implored plaintiff to leave the defendant alone and cease involving defendant in her grievances with Ford and others. So she essentially told her, like, listen, I don't want to have nothing to do with this. Let me go to Exhibit 8. Because she's saying she told her she don't want to have anything to do with this. Let's see. Oh, she's showing her in the hospital. Oh my goodness. Oh, she laid it out for the court. Okay. I'm sure they did acknowledge, because and she learned the rules. You know, she didn't she used the Michigan law. So yeah, I can't read a lot of this stuff. Oh, I'm sorry in advance, but please stop playing in my face. We all know the Kitchenista has appeared on my channel and provided me with information regarding Darius Cooks. I wanted to check in with her because I was concerned that her voice was overshadowed with internal drama. My intent was only kindness and concern. However, the response I received was about another individual who had nothing to do with Darius. A short time after that, my mother took ill and I had to return to NYC to look after her. Social media related emails were of no concern to me. So I didn't respond, not because I don't. So I didn't respond not because I don't care, but because I was just busy with life or death matters. Wow. As soon as I got home, I began a course of medical treatment that culminated in surgery yesterday. So I definitely wasn't checking social media. She has definitely provided the court with a lot of proof of line by line of everything to prove her case. All right. Let's get back to it. Let me try to get through these facts before I go back down here. Around the same time, an anonymous account by the name of Shits and Skittles appeared on Instagram, Twitter, Lipstick Alley, and Reddit, posting false allegations against defendant and tagging defendant in multiple posts throughout the day. From September 2022 until February 2023, despite the fact the defendant had blocked this account, these false allegations substantially amounted to a claim the defendant had knowingly promoted a fake lawyer. Thereafter, Lavelle Baker, a mutual associate of plaintiff and defendant, and an interview subject of defendant informed defendant that plaintiff is the individual behind this account. Baker knows that plaintiff is the individual behind this account because plaintiff told Baker this directly. So apparently there was a anonymous account called Shits and Giggles. They started doing false allegations against defendant and then tagging her in it. And Natalie was advised by this Lavelle Baker that allegedly the Kitchenista was behind this anonymous account. So then you got your legal authority or the standard of review. She has C7, but C7 is typically when you have a settlement agreement, statute of limitation, those type of issues. I didn't really see that. She does talk about the First Amendment in here. Let me go down here. Because of the importance of protecting the right to freedom of expression under the First Amendment in cases in which public officials or public figures sue for defamation, courts must conduct an independent review of the record and analyze the alleged defamatory statements at issue and their surrounding circumstances to determine whether those statements are protected under the First Amendment, and that's Graham v. Doe. Whether a statement is actually capable of defamatory meaning is a preliminary question of law for the court to decide. So that means the court can decide that it does not have to be a factual issue for the jury. Under MCR 2.116C8, the court should dismiss a plaintiff's claim where it has failed to state a claim upon which relief can be granted. I talked about that earlier, so we don't have to go over that. A plaintiff claiming defamation must plead a defamation claim with specificity by identifying the exact language that plaintiff alleges to be defamatory. I told you guys that earlier in the live stream. For a claim of libel, a plaintiff must plead, quote, the very words of the libel. Accordingly, several questions of law can be resolved on the pleading alone, including 1, whether a statement is capable of being defamatory, 2, the nature of the speaker and the level of constitutional protections afforded the statement, and 3, whether actual malice exists. If the level of fault the plaintiff must show is actual malice. As you guys seen from the complaint, there was no actual malice that was even pleaded, nor were there specific statements that were made. So then she talks about defamation. We'll just generalize this. A plaintiff in a libel suit must prove 1, a false and defamatory statement, 2, of and concerning the plaintiff, 3, an unprivileged publication to a third party, and 4, fault amounting to at least negligence on the part of the publisher, and 5, either actionability of the statement irrespective of special harm or the existence of special harm caused by the publication. And then it goes by whether a statement is substantially true is in the first instance a question of law to be decided by the court. And then it has Cognac v. Heritage newspaper. If the court concludes that the plaintiff cannot prove material falsity, the case is over. The court need not and should not reach any other aspects of plaintiff's claim. See Hawkins v. Mercy Health Services, which held that whether a statement is false is to be determined independently from the question of fault. So then she goes into actual malice. Plaintiff admits that the applicable standard of fault is actual malice. This is the correct standard because plaintiff is a public figure who must prove by clear and convincing evidence that the publication was a defamatory falsehood and was made with actual malice, i.e. with knowledge of falsity or with reckless disregard for the truth. And that's the Hawkins case. And then a court may determine that as a matter of law. I mean, it does not have to go before a jury. Where no such meaning is possible, summary disposition is appropriate. Reckless disregard for the truth is not established merely by showing that the statements were made with preconceived objectives or insufficient investigation. And that's Kefkin v. Davison. Rather, reckless disregard is measured by whether the publisher, in fact, entertains serious doubts concerning the truth of the statements published. So this is all. She's letting you know the law that is going to be applied to her facts. Then she goes into intentional infliction of emotional distress and torturous interference. She goes through the laws on proving that, and then false light on how to prove that. So then she goes into the argument. So when you have the argument, you apply all those laws we just read, and you apply it to your facts, is what she's doing now. So let me go back to the comments because y'all, I done read a lot. Let's see. Let me go. Yeah, make sure you guys hit the like. My brother said, I never had an issue with Darius when I ordered items. I even did a dinner with Darius and had to change dates. I had to travel for medical reasons. I had no issue. Not sure how he's a scammer. Well, apparently he is, Stephen, according to all these people. So you must have, according to these people, not according to Pam, Darius. So don't be coming for me because I see how you guys do on this here internet. But you have one good review. My brother just said that you did not, that you were great. So everybody don't have the same experience, apparently. What did he ask? What did she ask for in damages? That's another issue. She didn't ask for anything in damages. She just said she was damaged. That account would incessantly tag Natalie in all sorts of slander. Wow. This is crazy to me. Do you guys not think something is wrong with this? I'm just like, what? Okay, Miss B said, I'm a Darius fan. Numerous purchase with 0 issues. Great communication directly. 4 of us attended. Okay, we got another review. Okay. So everybody don't have these issues with Darius. Okay. Daphne said the news doing segments on him for no reason. He's banned from several platforms for no reason, huh? Let's all get along in the chat. We all have our different opinions and different experiences. They've written articles and local news crews have done exposés on him. People receiving Modi pound cake, child. Oh my goodness. It's wild. Lil Baby said, in order to continue a scam, there are a number of people who have to continue buying into you. So some people will get what they purchase while others will get the shaft. Okay. This is all opinion and allegations. Let me put my little banner up because y'all, don't want no problems. This is all commentary. We just giving our opinion because these people litigious these days. Okay. If you guys have not watched the video I did when he was in court on that Melanie Ford's thing, it was definitely worth the watch. If you haven't done so, go over there to that video and give me some views over there. Mel has the doxing documented. Just dumb ignoring the attorney to say stop. Lynn said I received books and cake from Darius with no issues. So we have another satisfied customer here. Terry said, I'm glad that I received my merchandise. I never knew about any of this. Oh, wow. Oh my. Darius has a voice recording of Melanie's threatening him. Oh. Natalie acquired subs from legal coverage of Depp v. Heard, which appeared around the same time of Kitchenista and Darius Cooks' social media. Natalie was already on the right. I wasn't talking about Natalie. I was saying Kitchenista. Because Kitchenista has to show damages. Natalie doesn't have that burden. She's out the case anyway, as we'll see in a minute, but she didn't have that burden. When I made that statement, I was saying, since Kitchenista is saying that she was damaged, just so I can clarify, when she was saying that she was damaged, what if you go back and you see that it actually helped her by going through this controversy on the internet? How would you overcome that? A lot of this stuff is new, what we call issues of first impression for courts, because now we have so much social media, we have YouTube, so a lot of this stuff will evolve. And we do know that some people's pages do increase and some people's followers increase, some people's revenue increase because they have beef. So even if they're talking derogatory towards you, but you don't have any damages because of that derogatory conversation that you have, or defamatory, what you allege is defamatory, how do you say damaged if you really benefited from it? I just think it's going to be a very interesting issue that has to be litigated eventually. Because if I was the attorney, I would go back to see, like, okay, so you have to prove damages. And because it's not defamation per se, pro se. So when it's defamation per se, you don't have to prove damages. You just have, but these don't fall under the category of defamation per se, those 4 categories. So you're going to have to prove your damages. So like how far back are we going to go to show when you started doing this hashtag? How far back do we show that it benefited you is what I was saying, just to be clear. I know Natalie was doing her thing before this. So, but this all started over some cookbooks, according to you guys, right? Just so I'm some recipes that were allegedly plagiarized. Melanie's was an early financial supporter of Darius. Then she saw what he truly was, a scammer. She didn't cut ties. Then he started attacking her and her husband. My. Hey, niece. My brother said we still in high school. To clarify, Darius has scammed customers, stolen recipes, concepts from fellow bloggers, got invited women. However, the Kitchenista was behaving obsessively over the people's experiences. Okay. Fake lawyer, my this is a lot. It's a lot in these documents. I didn't know that it was, my internet's been tripping. So hopefully we don't have any problems. It look like it's unstable right now. All right, let me see. I'm gonna go back over here to the complaint. When he was booking those events, Kitchenista was calling the local health department, law enforcement to get the event shut down. Y'all, she did a lot. Oh my goodness. I need y'all to cover me. I don't need to have no YouTube beefs. I can't take it. Joanne said I ordered cookbooks and they were good. I cannot and will not. I'm not saying he didn't do anything, but we've got 3 folks here with suspect behavior. Yes, there is the video. I want you guys. Thank you, Cupcake. I appreciate it. All right, let's get back to the issue at hand. Please make sure you thumbs up, hit that like button, and subscribe if you haven't done so already. I appreciate it, and I appreciate you. Let everybody know that we're on right now. Let me see. So her first argument is the court lacks personal jurisdiction over the defendant, a Maryland resident. We talked about that. A motion for summary disposition based on a lack of personal jurisdiction is resolved based on the pleadings and the evidential support submitted by the parties. And that is MCR 2.116C1 is where you find the jurisdiction. And then she just goes over jurisdiction. Basically, you don't have jurisdiction over me, judge. The second claim is plaintiff's defamation claim should be dismissed as a matter of law. Davis's claim of defamation fails to state the elements of that cause of action with sufficient facts upon which to state a claim. As a threshold matter, defendant has no idea what plaintiff is referring to by, quote, joined up with the Hollands, end quote. Defendant has never entered into an agreement with the Hollands in reference to plaintiff, nor threatened the plaintiff in any way, and plaintiff has provided no allegations to support the bald assertion. Defendant is also completely unaware of any threats or police action between the Hollands and plaintiff. Defendant does not even live in the same state as these individuals. However, on a motion for summary disposition, the plaintiff's allegations are accepted as true. A court may decide as a matter of law whether a statement is actually capable of defamatory meaning. So what she's saying is, when you file a motion for summary disposition, when the court looks at it under a C8, they look at their pleading and they give them the benefit of the doubt, pretty much. So it's you try to look at it in the light most favorable to the non-moving party. So the non-moving party is the person that did not file this motion for summary disposition. So they try to look into the complaint and give them the benefit of the doubt. They make it as if all the facts in there are true for purposes of this. So she got, quote, unhinged. Plaintiff fails to state when defendant allegedly called plaintiff unhinged, to whom this statement was made, and what the full context of the statement was. Simply alleging this word was uttered as recently as September 2022 on Twitter does not support the claims raised by plaintiff. A search of the defendant's Twitter account from September of 2022 for the word unhinged reveals that on September 30th, 2022, defendant was speaking to and about another individual, Bernadette Glacomazzo, with the Twitter handle, and she has the Twitter handle. The person appeared to be a fan of plaintiff who, following plaintiff tagging defendant on her large Instagram platform, began attacking and threatening to grieve the defendant. So they were threatening to call the state bar? Oh, this has gone too far. You playing with people's livelihoods on the gram. Like, this is ridiculous. Threatening to grieve the defendant, make the defendant lose her license to practice law, and get the defendant fired. It cannot be this serious, y'all. You guys got to help me understand. This could not be this deep. In response to that behavior, defendant used the word, quote, unhinged, and specifically made clear that she was not talking about plaintiff or calling Giamazio herself unhinged. And she has the exhibit. The fact that defendant must go on a hunting expedition to find that what plaintiff is referring to only serves to prove that plaintiff has failed to state a claim for defamation. Even if plaintiff were to plead with particularity, this is a statement of opinion, not a statement of fact, and therefore could not be actionable. I'm going to have to agree. I don't think unhinged is that sounds more of an opinion. But nevertheless, she's saying she ain't even say that to her anyway. She didn't call her that. And she had to go on her social media to try to search the word to see when she even used it. And it wasn't even referring to her. In Ireland v. Edwards, a mother and limited purpose public figure sued the attorney of the father of her child for death. I remember this case. Yeah, so essentially in that case, it was like during arguments, they didn't like what the attorney said. So um they tried to sue him for defamation, false light, invasion of privacy, intentional infliction of emotional distress regarding statements the attorney made, which amounted to calling her a bad mother. The trial court granted summary disposition in favor of the attorney defendant and upholding the trial court's decision. The Court of Appeals of Michigan held that, quote, defendant statements regarding plaintiff's fitness as a mother are not actionable because the question of whether someone is a fit mother, like the question whether someone is absolutely ignorant, is necessarily subjective. Here, too, the question of whether plaintiff's behavior was unhinged, taken in full context of the dispute, is necessarily subjective and not actionable. The next quote was upset, the attention is not on her, and sick. So she's taking whatever quotes that she did put, that the Kitchenista did put in the complaint, and she's saying why doesn't amount to defamation, and she has not pleaded the case. This allegation also fails to plead a claim for defamation, as there is no allegation as to whom the statement was made or when it was made. However, even if the pleading is sufficient, read in full context, liability based on this or any of the alleged statement is constitutionally impermissible. In Greenbelt v. Bresler, the Supreme Court recognized that some statements read in context are not capable of defamatory interpretation. There, the case involved the use of the term blackmail in reference to an ongoing dispute over contractual negotiations. The Supreme Court found that even the most careless reader must have perceived that the word was no more than rhetorical or hyperbole, a vigorous epithet used by those who considered the developer's negotiating position extremely unreasonable. In this case, on September 21st, 2022, defendant tweeted, so she's saying what her tweet is, quote, I'm only exposing this because I'm not the first person she's done this to, nor will I be the last. Angela is upset that the attention is not on her, and instead of participating in the movement, she attacks anyone that she thinks gets more attention than her, and it's sick, end quote. This was posted after plaintiff tagged defendant on Instagram and allegations of abuse because defendant refused to pledge not to highlight other alleged victims of Williams. So it sounds like Natalie would not agree to only talk about her and not highlight other people that were alleged victims of Darius. The use of the word sick in reference to plaintiff's behavior was rhetorical hyperbole, barely a vigorous epithet used by defendant because defendant believed plaintiff was being unreasonable. All of defendant's alleged statements are protected statements of opinion because they are not provable as false. Plaintiff alleges, quote, Miss Whittingham Burrell also made numerous accusations and false allegations that plaintiff was harassing people from anonymous accounts without any rationale basis for making such accusations. A plaintiff claiming defamation must plead a defamation claim with specificity by identifying the exact language that the plaintiff alleges to be defamatory. For a claim of libel, a plaintiff must plead the very words of the libel. Here, a plaintiff has only provided a vague allegation about plaintiff using anonymous online accounts. This assertion is made with no further specification of precisely when the alleged defamatory comments were made, precisely what those defamatory comments were, and to whom those defamatory comments were made are all elements of defamation. This failure necessitates the conclusion that plaintiff has not stated a claim of defamation. You guys see where this is going, right? You see where this is. Davis has failed to show that Whittingham Burrell acted with actual malice. And we talked about that early on. The standard to be applied here is not whether the defendant had any rational basis for making the alleged statements about plaintiff, but instead whether the defendant acted with actual malice in doing so, because to her own admission, plaintiff is a public figure. The appellate courts of Michigan have found summary disposition in favor of the defendant to be appropriate in the following scenarios. So she lists different times where they found it was appropriate. Number one is the attorney for the father in the custody dispute alleged that the mother never spent a moment with the child. It was not factually true that the mother never spent time with her child. A newspaper published a photograph incorrectly identifying the plaintiff, a city police lieutenant, as another police officer who stalked a former mistress. Number 3, a school board public relation director circulated a memorandum in which she alleged that the plaintiff doctor screamed at her and threatened to fire her several times. Officials of the American Medical Association labeled Doc Kevorkian a murderer. Do y'all remember Dr. Kevorkian here in Michigan? He was doing the assisted suicides. He was helping those that were terminally ill if they wanted to end their lives. And he was in trial here for that. The Finnish journalist reported that plaintiff, an elected sheriff of Oakland County, was accused of stealing food from the county jail and other improprieties. In this case, the source for the reporting never actually said that plaintiff stole food. Plaintiff radio host sued because the defendant wrote an opinion piece identifying him as a leader of the Ku Klux Klan. There was no evidence that he was the official leader of that organization. I think that was the case with a local radio host on 910. His name is Bankalay Thompson. And he's a very controversial person. But anyways, they're letting you know this is not considered actual mess. Here, plaintiff's allegations all fall within the ambit of these and other cases decided within this state. The first 3 allegations, unhinged, sick, and attention seeking are statements of opinion and could not have been made with actual malice, as they were not assertions of fact. As to the allegation that plaintiff uses online accounts to harass people, defendant believes that this is a mischaracterization of defendant's written words. Defendant believes that on December 30th, 2022, defendant wrote on Twitter, "This shits and giggles is Angela." Defendant does not believe that she said this account was harassing people or that plaintiff was harassing people from anonymous accounts. However, based on defendant's own conversation with plaintiff, the information provided by Lavelle Baker and the fact that plaintiff shared with her social media followers that she would be posting from anonymous accounts, and her sharing those online accounts with her fans, defendant had the reasonable and good faith belief that plaintiff was posting harassing messages from those accounts. Defendant's claim is also substantially true. In addition to one of these accounts accusing defendant of knowingly promoting a false lawyer, plaintiff also shared that account's request for anonymous accounts burners to assist with spreading her message on Lipstick Alley and Reddit. The account Shits and Giggles also sent harassing tweets to defendant for months from September 2022 to January 2023 following defendant's dispute with plaintiff, and plaintiff shared these messages to her Instagram. On the website Lipstick Alley, it is defendant's belief that plaintiff posts from the anonymous account Black Cardamom, which features a profile picture of plaintiff with that appears to be marijuana smoke partially obscuring her face. When that same account, plaintiff posted directed messages and emails between plaintiff and defendants that could only have come from plaintiff's Instagram account. This is unbelievable to me. This is absolutely unbelievable. Then she said, okay, this is another one. She's saying that she is libel proof. If you guys follow me, you know that I talked about libel proof. There are some people whose reputation you can't damage. Like there is literally a law in a lot of the states that there are some people whose reputation is just so bad they call them libel proof, that I can't mess your reputation up even more than what it already is. So this was one of the allegations in here. And so she says, in Kevorkian v. AMA, the Michigan Appellate Court found that Dr. Kevorkian voluntarily exposed himself to the risk of defamation by injecting himself into public controversy. The court also found that the issue of assisted suicide was one of public concern. Therefore, we must accord maximum protection to defendant's speech about plaintiff with special solicitude for their speech on a matter of such urgent public concern. Here, like Dr. Kevorkian, plaintiff voluntarily inserted herself into the controversy surrounding the alleged misdeeds of Williams. The issue of Williams' financial dealings and alleged doxing became one of public concern. Around June of 2021, plaintiff began making multiple social media posts on Twitter about defendant Williams, in which she amplified the accusations against Williams. These Twitter postings received national attention, and as a result, articles were published in highly regarded news sources with interviews from plaintiff. As she has listed all of these news sources in her footnote, plaintiff's statement set off a firestorm of social media attention to both Williams and Davis. Before this, plaintiff's celebrity was mostly limited to the niche area of the online culinary word following the exposing Williams plaintiff gained an increase in followers across all social media platforms. Okay, so she answered my question for me. So it sounds like following the exposing Williams plaintiff gained an increase in followers across her platforms. Thereafter, the plaintiff began to threaten to, quote, expose supporters of Williams' new rules. When you defend Darius Cooks, excuse his doxing, or any of his other crimes, you will be screenshot for a public gallery of ridicule. I will not redact your name. Other Black women deserve to know they can't trust you to protect them. Oh my. And then she has the exhibit, I guess, when the Kitchenista allegedly said this. In response to statements such as these, plaintiff herself came under intense scrutiny. In essence, plaintiff lowered her own estimation within the public discourse surrounding Williams. For example, and she let us know that she spelled it just how it is. So if it's any misspellings, that's not her. So she has a list of different tweets that people sent out regarding the Kitchenista. So one is on August 22nd, 2021. At Chantel Neek tweeted, I mean, at what point do something becomes bullying? The Kitchenista and Darius Cooks beef is getting crazy. 2 on August 22nd, 2021, someone tweeted, girl, right, she miserable as hell. Her fans don't love her. Number 3 on August 26th, 2021, someone tweeted, son, it's no way Kitchenista still at it. I unfollowed like 2 months ago, and you mean to tell me she's still going? 4 on August 15, 2021. It was a tweet. I mean, I get bringing awareness to something, but Kitchenista been going for over a month, laughing my ass off. Like, get some PTO, take a vacation, get some R&R. It's bordering unhealthy obsession. Number 5, and somebody I think they said that in the chat. Number 5 on August 24, 2021, there was a tweet. I had to unfollow because she's harassing people now. Number 6 on August 24, 2021. I mean, whatever crusade Kitchenista was on against Darius seemed warranted. And who am I to tell someone how to spend their time and energy? But including other people and being hateful to other people, that's just ugly and doing way too expletive much. On July 6, 2021, it was a tweet. That Kitchenista lady is messy. This doesn't shock me. And I don't know anything about this Darius Negro except that his recipes are offensively bad. On July 7, 2021, the Kitchenista lady is on a one-way super slide to being canceled. You can't be the victim and the bully. Literally taking and using a man's videos to mock him after she told the world she wanted nothing to do with him because he harassed so bad that she felt attacked. August 17, 2021, that Kitchenista lady is still talking about that man and his lipo. Give it a rest, lady. It's a bad look now. So Darius had lipo too, allegedly. On August 24, 2021, someone tweeted, that Kitchenista lady got all kinds of bad energy about her. I get that she wanted to expose old boy, but at this point, dude could just sue her for defamation and pay everybody he's stiff with that. Number 11 on June 17, 2021, that Kitchenista lady going out all bad. It's bad to watch. On July 30th, I like Kitchenista and she works hard to get where she's at, but this feud she has going, I don't know, man. It's just bad energy. That doesn't seem to be changing much. Hope she finds her peace with the whole thing. June 11, 2021. Wow, that's insane and kind of deserved because Kitchenista is not a nice person, not in the slightest. She got a whole list. September 21st. I'm sorry, but the Kitchenista is off her rocker. This is a mess. January 6th. Is that Kitchenista chick still running crazy all up and down the timeline? On January 28th of 2022, does Kitchenista still be going back crazy over Darius Cooks? Is that beef resolved? On August 27, 2022, Kitchenista's behavior is unhinged. Darius is a scammer and a terrible person. Two things can be true. It's getting weird on Kitchenista's end. August 16th, Kitchenista needs to stop giving the scammer free promo. It's giving unhinged at this point. August 24th, the Kitchenista saga is really fun because it started with seeing a woman drag a sassy garden known for being fraud, not knowing how to cook, and now it's turned into a woman becoming fully unhinged and mobilizing a cult to attack people. Can't wait for the next chapter. August 24th, somebody tweeted, she just said she ain't gonna stop. She's not gonna apologize for bullying someone that had nothing to do with any of this. If you still supporting you, the problem too. She has no boundaries. On July 16th, the Kitchenista is unhinged, not her trying to send minions after me, please. August 24th for 2021, I knew the Kitchenista was unhinged, saw that coming a mile away. August 24th, this whole Darius Cooks and Kitchenista situation has completely fallen off the rails. Like at first, it was understandable from her standpoint, but she has become unhinged, like you targeting innocent people now. August 29th, 2021, at they tweeted, I'm never going to be the person to tell someone how to react after they feel they've been wrong. But this ish with Kitchenista is and has been becoming very unhinged. August 24th, 2021. Yeah, the Kitchenista is unhinged. It's been months. Leave that man alone. August 28th, that Kitchenista girl in her stand seemed very unhinged. God bless. Kitchenista is a great cook, but she doesn't own shrimp and grits. This attacking anyone and everyone who might associate with Darius is unhinged. We saw your points. Most people don't want anything to do with him. Move on for the sake of your brand. Move on. August 29th, Kitchenista is crazy, man. August 25th, 2021, the Kitchenista lady is for sure crazy. August 24th to 2021. No doubt Darius Cooks is a scammer, but Kitchenista is also crazy. Two things can be true at once. And then April 5th, 2022, someone tweeted, Kitchenista's been tweeting behind a burner account all this time. I'm not surprised. Got to give it to him. I'm looking at the comments. Got to give it to him. He takes nothing sitting down. He has the time and the money. And she had a pretty big following on Twitter, so I'm sure you all could imagine how many tweets there were between her and her followers. Yeah. You said, well, lay it out there, right? So since she lost followers, she is blaming Darius because he had influence to make people unsubscribe to her. Yeah, but he's the same person that allegedly gave her followers too. So how does that work? I don't know. This could be a TV show. Too Feisty said this went on an entire summer. The Kitchenista, Andrea said the Kitchenista became the thing she complains about. Wow. So she listed what the other folks were saying. He said, not a burner account, dear Father God. And Kevorkian in the appellate court defined the concept of plaintiff being libel proof as a matter of law. In those instances where an allegedly libelous statement cannot realistically cause impairment of reputation because the person's reputation is already so low, the claim should be dismissed so that the cost of defending against the claim of libel, which can themselves impair vigorous freedom of expression, will be avoided. Here, like Dr. Kevorkian, plaintiff's celebrity arose from her exposing Williams. In turn, her own notoriety and low estimation in public opinion appears to have arisen from the perceived hypocrisy of plaintiff allegedly threatening Williams' supporter. As a result, the statements attributed to defendant in this suit have all been said about plaintiff for years. This is mostly due to plaintiff's very own action. The effect of defendant's alleged statements are de minimis. To target defendant in particular, where so many others have opined that plaintiff is, quote, unhinged, quote, sick, attention seeking, or that she posts from anonymous accounts, leads to an untenable burden on Michigan courts to sustain claims against uncountable internet users across the globe. Yeah, so what you gonna do? Do a class action or something and kind of sue everybody who said that? The concept of being libel proof set out of Kevorkian has not died with that case. In Edward v. Detroit, a radio show host sued a newspaper and author of an opinion piece which asserted that plaintiff was a leader of the Ku Klux Klan. Summary disposition in favor of the defendants were granted, even though there was no evidence that Edward ever held an official position within the Klan, because Edward's own words and deeds lend plausibly to the colloquial interpretation of the leader. So y'all get it. And then she says the plaintiff's claim for defamation per se must fail. Plaintiff alleges that defendant's accusation and publications thereof were defamation per se. Plaintiff has not pled the claim with particularity. Statements imputing a lack of chastity or the commission of a crime constitute defamation per se and are actionable even to the essence of an ability to prove actual or special damages. We discussed that. Here, plaintiff has pled neither. Plaintiff's allegations that defendant said the plaintiff was harassing people from online accounts was colloquial. No reasonable person could conclude the defendant was referring to a crime of harassment as opposed to the common use of the term heated online. And then, of course, IIED, she probably just basically said you have not pled that. Torturous interference should be dismissed. Claim for false light should be dismissed. So based on the foregoing, she asked that her motion for summary disposition be granted. She also asked for sanctions for bringing this action without a basis for fact in law or a good faith extension of law. So that is her response. Very well written, like I said, especially for her not to be from here because we do have a little quirkiness in our law. Yeah, she did. That's why I said it's actually worth, it definitely was worth reading. This was a lot, right? So then I was like, well, what is the attorney gonna respond to say? Because she broke it down. I kind of saw that looking at the face. Most of the stuff she just said, this is the first time I've read it in its entirety. You see, it's 20 pages. That is her motion. It's 141 pages. That's because she has a bunch of exhibits. All of her exhibits back up everything she said. Whatever she's quoted within this document, she has attached that she can prove. There was a response. I'm trying to see what his argument is. He pretty much, the attorney for the Kitchenista, she pretty much rehashed the same statements that were in the actual complaint. Yeah, all this stuff is the same. So you go through the standard of review. So they're saying the court has personal jurisdiction. Defendant first argued that this court does not have personal jurisdiction over her due to her residence in the state of Maryland, lack of any long-arm statute to pull defendant to the court's jurisdiction, primarily while defendant's motion for summary disposition fails to plead the issue under MCL 2.116C1. That's what I was saying. It was, she's not from here, but it's actually MCR. Why you the attorney from here? It's the Michigan court rule. That's not the Michigan compiled law. Imagine trying to tell somebody you didn't plead it right. The defendant still addresses the issue extensively under existing case law, for which reason plaintiff addresses this issue in its entirety here. MCR 2.116C1 provides the grounds upon which court may grant motion for SD, and then it has the standard. So what they're saying is that, remember so under MCL 600.705, however, lists instances a court is able to exercise limited personal jurisdiction over an individual and therefore render personal judgment against the individual or his representatives arising out of an act which creates any of the following relationships. So if you look at number 2, the doing or causing of an act to be done or consequences to occur in the state resulting in an action for tort. So defamation is considered a tort. So they're saying because the tort was committed against her in this state, they should have jurisdiction. The problem is, according to Natalie's response, you still wouldn't have jurisdiction. You have to do it one and the same almost, because the court is going to decide whether there was a tort. Because if there's not a tort and she's an out of state resident, then obviously there wouldn't be jurisdiction. So the court will analyze whether there's a tort. So he's trying to say under this rule, because it was a tort that affected a resident that was here, then there is jurisdiction. Then he claims the plaintiff's defamation claim was pled sufficiently. And plaintiff has set forth sufficient facts with regard to malice that necessarily demonstrate the existence of genuine issue material fact. Defendant makes a number of missteps in her argument with regard to malice. Primarily, defendant assumes that plaintiff is a public figure and is thus subject to a showing of malice rather than negligence with regard to her defamation claims. So he's alleging that the Kitchenista isn't a public figure. And then he says the second misstep in her argument arises when she argues that plaintiff fails to show actual malice in her pleadings by asserting additional factual information from her perspective and attempts to disprove plaintiff's assertion of malice. This is in itself makes summary disposition inappropriate at this juncture. Defendant seeks to show that no facts exist or may be pled which may justify recovery, that no genuine issue of material fact exists. However, plaintiff asserted one set of facts to show malice while defendant asserted another, and defendant's assertions are based on the communication with defendant Williams, which will be proven or disproven over a course of further litigation in this matter. For this reason, defendant's motion is premature. Remember, that's what I told you in the beginning. When you do anything on a MCR 2.116C10, typically you don't do those till after discovery. So what he's trying to say is we're early on, Judge. We haven't got into this case. This is in the beginning. So because this is the beginning, we may stumble upon some more information. So this is premature for her to be filing it. But the issue is she also did it under a C8, which is you don't look outside of the pleadings. Look outside of the pleadings, adding other documents. I'm saying based on the face of your complaint, you don't have a claim. So that was his argument. So then about the libel proof, defendant's next argument that plaintiff is libel proof is far attenuated from any realistic application in this matter. And he uses a California case. Is that CA? No, he's saying this is the Sixth Circuit, but this is a federal case. Brooks v. American Broadcasting. We are in the Sixth Circuit, but this is a state court case. So they use the federal court as their authority on a libel proof plaintiff. Trying to see if they say anything. Now he's saying defendant's conduct satisfies standards set forth for defamation per se. Defamation per se involves a statement holding the plaintiff up to hatred, scorn, contempt, or ridicule, or made with malicious intent. Words that damage a person's business are false constitute defamation per se. A plaintiff can recover actual damage based on injury to property, business, trade, profession, occupation, or feelings. Moreover, exemplary and punitive damages can be recovered if malice amplified injury. The entirety of defendant's argument with regard to defamation per se can be summarized as the oft-used juvenile claim of "I was just kidding." While that argument may work between children on a playground, he was getting feisty. It certainly cannot stand on the basis of a summary disposition argument here. The defendant did more than simply make colloquial statements of opinion. She made serious accusations against plaintiff and questioned plaintiff's mental stability, all of which led to measurable actual harm that plaintiff suffered. Plaintiff lost out on deals, potential business relationships, and expectancies, as well as her mental health. Certainly, the standards set forth by Michigan courts have been satisfied, and defendant's motion must therefore be denied. Then they go through IIED, torturous interference. So those were the main responses. And as I told you guys in the beginning, so they had oral argument. I don't know what date their oral argument was. I assume it was on Zoom because a lot of our stuff is still on Zoom. After the oral argument, the court agreed with Natalie, and it's granting defendant's motion for summary disposition and dismissing the complaint as to defendant. Upon reading the defendant's motion for summary disposition, plaintiff's response and opposition, defendant's reply brief, entertaining an oral argument in open court. Okay, so it was on May 1st, 2023. They got 2003's typo. And the court being otherwise further advised, it is hereby ordered that defendant's motion for summary disposition is granted for the reasons stated from the bench. So essentially, in order to know the factual meat of why the judge ruled the way he ruled, we would have to get the transcript. So most of our orders will say for the reasons stated on the record. So it has MCR 2.116C1. Basically, there's no jurisdiction MCR 2.1168. Basically, there you haven't stated the fact. It's not on the C10, so it's based on the pleading. And plaintiff's complaint is hereby dismissed as to defendant Whittingham without prejudice. Now, that's what my issue was, is the without prejudice. Because I can almost guarantee you, without reading that transcript, that attorney probably asked the court to amend their complaint so that they can ask for particular, that they can correct whatever errors is in that complaint. If the court denied the ability to, because here a motion to amend should be freely granted. So if the judge denied that, that would mean the judge believes that it would be futile for him to do it. That means you can amend it if you want to, but you're going to be in the same situation because you just haven't pled defamation. So the fact that he did it without prejudice, in my opinion, even though he is the honorable judge and he's been practicing way longer than me and been on the bench for at least 20 years, I think it should have been with prejudice. I don't think it should have been without prejudice because it's based on what your complaint was. But he did do it without prejudice. When you do it without prejudice, in theory, that he or she, whoever, can refile. This should have been with prejudice, in my opinion, so they wouldn't be able to refile. But I doubt they're going to refile it because not based on any of this that they said. So let me go over here to the comments. You said he would have shut this down. All right. Hey, who said that? Good to see you. Natalie asked Still Nice. She advised her that her lawyer was doing her a disservice because this should never have been filed. Meanwhile, the Kitchenista is actually an excellent cook and provides great events. I hope she's somewhere prospering, but this really became too much. Yeah. She got to focus on her craft. Might have got side. Again, I'm from the outside looking in. I don't know any of these people. But she may have just gotten sidetracked. That's all. And so she just got to get back focused. Clearly, she was very adamant on trying to the movement, as it pertains to Darius Cooks. But the attorney filed a civil lawsuit with really no money attached to it. You can't sue for losing files unless you can prove those files brought you a certain revenue. Correct. And so there was a few motions that were filed. So Darius is trying to have an attorney represent him that's not from Michigan. So I know he has a motion which we call Pro Hoc VJ, which is to have them come in for this one time only, and you work up under a local attorney. So I know that motion is up. I believe it's tomorrow to try to get his attorney to be allowed to come in. I don't see no reason why they wouldn't. There is also where the Kitchenista has filed. She's trying to make this case be under seal. So she filed a motion to seal this case from the public. There's already a protective order that's in place, which is common because protective orders, essentially, when you file stuff, they don't want you putting there, like, say she gives them her financial information. She gives them her bank accounts, or she did intentional infliction of emotional distress, which is a medical issue. You're going to have to prove that. Like, you're going to have to come with some type of psychological records or whatever. So those type of records, you usually do protective orders because you don't want, when we file these motions for summary disposition, you see how we attach a bunch of exhibits. We don't want you filing personal discovery stuff out here. And then it's easy, like how I was able to just get the documents. It's easy for the public to get them. So I understand the protective order part. Now, sealing the entire case, I don't understand what would be the purpose of that. But I guess we'll see tomorrow what the rationale is that she wants to seal. So I don't know if she wants to seal after she lost this part with Natalie. So she don't want the people to be able to talk about it. I don't know. But I'll find out and I'll definitely report back. And then Darius has filed a motion for summary disposition. And it looks like he's done it based on C1, 2.116C1, which is the jurisdictional issue because he's not from here. He's from Georgia. So I have not gotten his pleading yet. But, it may be something I just put in the membership. Also, so if you're not a member, go over there and become a member. Because if I don't know if this is on Zoom or not, if the judge is making them come in person or how it's going to go tomorrow or any of these other times, but if I can, I'll show you guys how to get on there if this judge actually streams on Zoom. Everybody doesn't stream their stuff on, we can go on Zoom, but everybody does not stream on YouTube, I should say. But we actually have a list of how, like, you can click on courts and you can view what's going on in the court, but every judge doesn't click that on for the public to view, I should say. So the duck fat added a richness to the cornbread, never thought to use it. You know what, you guys talking about recipes, now you're gonna make me hungry. He should win that as well because he's right, wrong jurisdiction. Yeah, but the problem that he's gonna have to also talk about the allegations against him, right? Because you can, under the long arm statute, you may be able to pull somebody into our jurisdiction depending on whether they were affected. They affected someone that is domiciled here. And in order to prove that, you're gonna have to show, almost like how Natalie did on a C8, that on the face of the pleading, you don't have a claim. You don't have a defamation claim. This is going to be very interesting because I'm sure whoever Darius's attorney is, they're going to go back and forth on what they said about each other. Like, you seen that stream where people were saying, like, it's to a point the public was thinking that some of the things were that she may have said could amount to defamation, according to what some of the Twitter said, not Pam. That's what some of the people on Twitter said. So it sounds like they'll be going back and forth in court. But she's trying to get it sealed. So if she gets it sealed, I guess we won't see any other documents. So, because it'll be an order where he wouldn't be able to show anybody as well. But I don't see why the court would seal it. They don't just allow you to seal documents like that without a real explanation to it. You said, well, he's in trouble then because he's on video doing every bit of what he said. You know what? That doxing is very, very interesting. I can't say that I am familiar with that claim that the judge used. So I would have to look into that, how they even litigate that. It's very interesting. Putting folk information out there like that. I just didn't know it was that deep. So when I read it, of course, I wanted to bring it to you guys because I know that some of you, I would surmise, actually follows him. So I wanted to make sure that I brought this information here because, again, this may be something that I cover more extensively just because it's here. So, all minds clear? What we got in these comments? See, I hate I see part of the comments because you guys have conversations with each other. Yes. For all of you guys that have been watching the YNW Melly trial, we resume on Monday morning. Next week, though, for the majority of the week, I will probably mainly stream in the afternoon because I have other things going on in the morning. But Monday, I will be there in the morning to restart this case. I believe the defense is going to start their case starting next week as well. Thank you guys. You guys are so kind. Thank you for the 212 likes. I appreciate it. Thank you for all of your attention. I know this can get a little boring, but it's very informative. And again, she tried to force another food blogger to join her despite that lady telling her she wanted to move past the negative experience with him and didn't want to revisit it. Yeah, I hope she can move forward. Yeah, you see what I'm saying? This is what I'm talking about. Nobody's trying to be funny. But see, that's why I said at first, I said, well, man, I'm gonna reach out to everybody and see, like, do you want to come on here and talk about it? And you know, if anybody reaches out to me and they want to talk about it, I don't have a problem with it. But I'm just not trying to get wrapped up like that. I'm just trying to, you know, talk about the lawsuit like we do over here. So That's all. I can't get caught up in this in these shenanigans. Y'all can't be stressing me out over YouTube and internet beefs. Yes, child. We didn't know this trial was gonna last this long. We trying to be diligent and see it to the end, but it's starting to get rough watching this trial, y'all. But it's interesting. It's interesting. He put out everything, ethics or lack thereof of someone doing that. Yeah. On your way out, make sure you hit that like and subscribe. I hope you guys enjoyed the live today. Thank you so much. We have a lot of cases on our plate that we will be following. Keep the emails coming in and the DMs on cases that you want me to follow. Did you guys see the 2-year-old that unfortunately we got an Amber Alert? It was like early Monday morning, 2-something in the morning, of a 2-year-old Winter Smith, and she was missing, and her mother was found stabbed, but she's alive. She went to her neighbor's house. Her ex-boyfriend is alleged to have taken the child, stole the lady, his ex-girlfriend's vehicle, which is Winter's mother, got in the car, drove away. They found him, arrested him, got him for kidnapping and stabbing the mom, but they were looking for the baby, and they found the baby yesterday. They found him on the east side of Detroit. All this was in Lansing, so they found him on the east side of Detroit. If you don't follow me on Instagram, I have a little clip that is on there, so go over there and watch it, because that may be something that I cover as well. It is tragic. And it definitely wasn't the outcome that we all wanted and prayed for. But these people out here sick. Again, this was the ex-boyfriend of the mother. So, yeah. It sucks. But anyway, I love each and every one of you guys. Thank you guys for hanging out with me. Again, I hope you guys enjoyed today's live. Again, shout out to all of the new subscribers. Make sure that you let everybody know about our platform. We were just a few away from getting to our next milestone, which will be 7,000. Yay to you guys, because half you guys started with me at about 50. And we were kind of talking to each other. Now we actually have people that come watch us. So, yeah. So, anyways, I am going to get off of here. We've been on here, so now we're 2 away from 7,000. So whoever 2 of you on here that have not subscribed, make sure you subscribe so that we can hit our next milestone, okay? All right. So for you, those of you that don't know, my intro is my son. I am praying that one day he do my outro, but it's not happening right now. So we do the outro the same time, with the same doggone intro. And let me take this banner down. All right. And so I am going to, I've been on here over 2 hours, I don't stay on here that long. But all right, guys, I will holler at you guys next time.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.